Thank you for joining. And we're going to be talking today about estate planning for divorced parents. And this is a really important issue, and I don't think enough people realize exactly how important it is. But from sort of sitting where I sit in terms of both the planning side and also the administration, when somebody does pass away or a tragedy happens, we really do see how this comes into play and some of the consequences that can occur if things aren't taken care of properly. So before we get started, I would like to just sort of get an idea of where people are in terms of their marital status, if they are considering divorce, if you are in the process of divorce, if you're finished with the divorce, if that process is done and you're free, just to kind of get an idea of where you may be in that process to make sure that I cover whatever your situation is. Okay. Okay, great. And also, if you don't want to participate in the poll, that's fine, but it is completely anonymous. Okay, so I think most people, their divorce is final, so I'm going to focus particularly on that. But if you are in the process of divorce, then I will just touch a little bit on that as well. So some of the concerns that divorced parents have, I think, is really arises a lot from the fact that there's no backup, or the backup might not be a great option. And so you might be concerned about who would take care of your child if you have sole custody, who would manage money left to your child, and making sure that your ex isn't involved in those managing those assets or have any kind of access to those assets. So in this webinar, we're going to make sure that kind of by the end of this, you understand how to make sure you document who would take care of your child, making sure that your child's inheritance is managed and controlled by somebody who you choose and trust, which is generally not your ex-spouse, protecting your privacy from your former spouse, and reducing the risk of interference in your estate plan by your former spouse. So just a little bit about who I am. I'm an estate planning attorney and founder of the Village Law Firm, where we focus on estate planning for New Yorkers and estate administration and probate. I am the author of The Complete Guide to Legal Planning for New York Parents. You can see my book. It's a great resource. I do recommend it, if I do say so myself. And so if you don't have it, actually, as you're on the webinar, if you want to send me an email, it's shannon@thevillagelawfirm.com or info@thevillagelawfirm.com. We'll send you a free copy of the book. I have my law degree from Georgetown and also a degree in tax law from NYU. And I'm also a certified financial planner, and that allows me to just be able to see our clients' situation, their financial situation, their family situation, very holistically when we do advise them. So there, before or during divorce, there is no, even if you've started the divorce process, there's no effect on your estate plan. So just because you filed for divorce doesn't have any effect. If you've already done your will, your healthcare proxy, it's not going to have any effect on those. So those documents will all still be valid. So you want to review those estate documents to make sure that they represent still the way that you would want to leave things and appoint individuals for certain roles. So you want to look at, are any assets left to your spouse? Is your spouse named as the executor in your will? Is your spouse named as your healthcare proxy? And is your spouse named as your power of attorney? Because those are all roles that are high trust roles, we'll just call them, that they you only want to appoint somebody who you fully trust in those capacities. So if it's your spouse and you don't trust your spouse anymore to represent your wishes in those scenarios, then you want to make sure that you make that change even before your divorce is final. So in the absence, if you are still legally married, in the absence of a last will and testament, your assets will be divided 50-50 between your spouse and children. Your spouse has the priority to serve as the administrator of your estate. The administrator of your estate is who manages your assets and wraps up your estate. That person, they are the ones who work with the lawyer to make sure all your assets go to the place they're supposed to go to. They have access to all of your accounts. And even more worrying is, or troublesome perhaps, is that they have access also to everything that you own. So anything in your, even if you're living separately, anything in your apartment, all of your personal items, all of that is your spouse would have access to. And the spouse would also be in charge of managing the assets left to any minor children. In the absence of a healthcare proxy, your spouse would have authority to make medical decisions for you. And even if your will cuts your spouse out, your spouse is still entitled to 1/3 of your estate in the absence of a prenup or a postnup waiving that right. Any assets that are left to children who are under the age of 18, those assets are supervised by the court, and the court appoints a guardian to manage those assets. So, and this applies whether you're married or not married or divorced. Any assets left to minor children, those children obviously can't manage those assets themselves. And so the court would appoint a guardian to manage their inheritance until they turn 18. And the guardian of those assets, the person who's managing the assets for the child, is usually the child's other parent. So even if you're divorced, anything that's left to your children, so if you are divorced and you pass away without a will, all of your assets are going to go to your children or to your child. And those assets would have to be overseen by this guardian of the assets, who would be appointed by the court. And that's usually, it's going to be the child's other parent, who is perhaps maybe your former spouse. That guardian, there is some guardrails for that the guardian must submit annual reports to the court for the public record. But one, it's in the public record now. It's not great to have sort of financial details about your kids kind of out there in the public record. And also it's on sort of depending on the county and the court. It depends on kind of how diligent they are with respect to checking those reports. And some courts are not very diligent at all, and they don't even notice if there are reports that haven't been filed. So what you can do before your divorce is final, you can update and create estate documents. So I would definitely recommend updating your healthcare proxy, your power of attorney. Your power of attorney is a document that authorizes someone to make legal and financial decisions for you. So definitely want to make sure that's somebody you trust. Updating your will. And you can change the executor of your will, the person who works with the lawyer and is in charge of gathering all of your assets, but the spouse still retains the right of election. And then generally, I recommend that parents create a trust, and we'll talk a little bit about that later. A common question that I get is what parents can do, like if you have full custody and the other spouse is not really a competent parent, then you may be concerned that if your child would sort of end up with full with your spouse, your former spouse would end up with full custody of your child. There's not too much that you can do about that. They do have that right automatically. But in cases of if there's documented emotional or physical abuse or substance abuse, then you do want, there is a chance that the court may appoint someone else. But you would want to make sure that all of that kind of abuse and incompetence would be well documented, and to designate somebody in your will as a different guardian, and discuss with them what that means, and making sure that they have all of the evidence and documentation about your the other parent's lack of ability to take care of your child, and make sure it's somebody who's going to fight for your child. Okay, so I'm just going to look at an example of how this plays out in the real world. And this isn't an actual story, but it is based on some situations that we have seen. So in this scenario, Jane has a 3-year-old daughter, Leah, and she got divorced from Leah's dad, John, because he refused to get a job, and he just hardly ever helped out at home. He just wanted to play video games all the time. And Jane didn't really ever think, she was 37 years old. She didn't think, well, I need to maybe do my will, but she got into a car accident at the age of 37 and passed away. She had no estate planning documents in place. So what happens at this point? So now John has sole custody of Leah. All of Jane's assets went to Leah under intestacy rules. Intestacy means if you don't have a will, what happens with your assets. And if you are divorced and you have a child, then all of the assets are going to go to that child. But here, Leah was only 3 years old. She's not old enough to manage the assets. So the court appointed someone to manage the assets for Leah until she turns 18. And the first in line for that role was Leah's dad, John. Jane's mother wanted to manage the assets for Leah, but she couldn't do that without John's consent, and he refused. So there was no way. Jane's mother was completely cut out in this scenario. So all of the assets were left in John's hands, and this is the guy who was terrible with money, refused to get a job. And on top of that, he was automatically appointed as the administrator of Jane's estate, because the way that if you don't have a will, then the court appoints an administrator, that person who works with the lawyer to manage the assets and get them to who they're supposed to go to, can access your apartment, can access all your financial accounts. That person, if there's no will, goes to it's done by your next of kin. That's the person who would have the first priority to serve in that role. In this case, that would be Leah. That would be Jane's daughter. Because Leah is not 18, she's not able to serve. Leah's parents, her surviving parent, can serve on her behalf. So here, John is appointed as the administrator, and he not only was able to kind of go through all of Jane's things, but also got paid for it, because the administrator is a paid position, and they are entitled to a percentage of your assets. So that can be a motivation that here in this case, John wouldn't want to give that up because he's going to get paid for that. So unfortunately, like I said, these are not real people, but these issues I have definitely seen more than once. So it can happen, it does happen, but there are ways to prevent it. So some of the lessons that we can learn, we want to have a comprehensive estate plan that controls who administers your estate, who has access to your assets and private information. You want to make sure that the assets that are left to your child are protected, that they are not left to be managed by your former spouse. You want to have a plan for incapacity. No, everybody really should have this, but especially if you are in the process of divorce, that person is going to be your sort of divorcing spouse. So you want to make sure that you have documentation in place of who would make medical decisions for you and who would manage your finances. And you also just want to make sure that your plan works in practice. That includes not just your legal documents, but updating beneficiary designations. For example, any 401k accounts, those trump the beneficiary that's designated on those accounts trumps your will. And if you have a former spouse as a designated beneficiary, that's the person who's going to get your assets, even if you're divorced. So you want to make sure that those beneficiary designations are updated as part of your comprehensive plan. And your lawyer should work with you to make sure that those are done properly. You also want to make sure that an emergency contact person has important information about your children and your finances. And this is especially true if you're a single parent, because you might not have, if you're a married parent, then the other spouse likely has a lot of that information. But if you are not married, if you're divorced or just a single parent, then you want to make sure that somebody would have access to a list of your assets. What is it that you have in place in terms of life insurance, in terms of where do you do your banking, what brokerage accounts do you have, all of those things. Because if somebody passes away, and we see this all the time, if they don't have information like that left somewhere, then the person who's managing their affairs is going on a wild goose chase trying to figure out where their assets are. And they are literally like calling all of the banks in New York City trying to figure out if this person had a bank account there. So it's really important to just make sure all the practical information is available, and also information about your kids. So do they have any allergies? Do they have any particular needs, medical needs, information about their vaccination records, their pediatricians, things like that. It's not per se a legal issue, but it's just as important, sometimes more important than those legal documents. So this is just an overview. Your will is really important, making sure that you designate an executor in your will. That's the person who manages your affairs after you pass away. And that person makes sure that they get to whoever they're supposed to go to. It also designates a guardian for your child. If a guardian needs to be appointed, the guardian is the person who takes care of your child on a day-to-day basis. It will also directs disposition of your assets, and it also requires probate court. So anything that goes through your will has to go through probate court. Basically, when we pass away, our assets are generally frozen, and nobody can access them until they get an order from the court. And that can take from a few weeks to years. Unfortunately, we have seen during COVID, it was taking like 2 years to get anything. So you can imagine during this time, like, there's so many bills that need to be paid: your mortgage, your childcare expenses, maybe your kids' school tuition, all of these bills. And if your assets are all tied up, unless your family has a tremendous amount of money, that it's going to be really difficult for them to cover those costs without access to your assets. So there are ways that we can avoid that process, and we usually do this through a revocable living trust. And this is a lot like a will, but it just allows the person who's designated in your trust to have access to your assets pretty much immediately without having to go through the court process. It's also much more private, and it gives, during probate court, there's a lot of opportunity for people to object to what your will says. And a trust minimizes or reduces the likelihood that somebody would be able to object to your wishes. So that's, if you were concerned about your ex possibly interfering in that process, then you definitely would want to have a revocable living trust. Okay, this is just a little bit more about the revocable living trust. And then in terms of the assets that are left to your children, you also want to leave those in a trust. And a trust is just simply, it appoints somebody who's the trustee to manage assets that are held by the trust for the beneficiaries. So in this case, you would appoint a trustee, maybe like one of your parents or a sibling or even a friend, to manage the assets for your children until they reach a certain age. And the funds can be used, so it's important that the trustee manage the assets for your child and make sure that those assets are used and available to the guardian of your child to make sure that the guardian is not financially burdened with those expenses. And it also prevents influence and interference by your former spouse, because they don't have full access to those assets. They have to ask, even if they're the guardian of your child, if they're taking care of the child on a day-to-day basis, that they have full custody, that they have to ask whoever it is you've appointed to be the trustee for money if they need it for your child. Okay, so this is just sort of a little bit, I'm a visual person, so I like to see a diagram of things. So this is anything that assets that are held outside of the trust will go through the court, will go through your will. So we want to make sure that all of your assets, the sort of catch to the revocable living trust is that it doesn't work to avoid the court unless assets are titled in the name of your trust, or that the trust is named as a beneficiary on accounts or life insurance policy. So that's another part of your planning that's important, that you want to make sure that whatever lawyer you work with, that they're helping to make sure that all of those assets are directed to your trust. Because sometimes, a lot of times actually, people set up these trusts and then they're never funded. The assets are never put into the trust or directed to the trust, and then it's sort of just a waste of money, frankly. And then once you pass away, the assets that are in that revocable trust will go into the trust for your children. And then the trust will be managed for those beneficiaries, who generally are going to be your children or other people who, if you choose. Planning for incapacity. So you also want to make sure that you are taken care of in accordance with your wishes if something happens and you are not capable of making decisions for yourself. And you want to make sure that you have in place a healthcare proxy and a power of attorney. Okay, so these are the key estate planning documents that I would recommend. The one that we didn't cover was the standby guardianship. And the standby guardianship is a way to make sure that your kids always have a guardian. So the person who's designated in your will to serve as the guardian, they have to be approved by the court before they have full legal authority to serve as the child's guardian. Because that can take some time, it always will take some time, it's not immediate, that we would want to put in place something called a standby guardianship. And that is a temporary guardianship that allows someone to take care of your kids until the court makes the formal appointment. Okay, and then beyond your legal documents, like I said before, it's really important to make sure sort of those practical things are taken care of, and that information is available to your trusted person, your emergency contact. If you don't choose, if you don't think that the child's other parent is fit to take care of them, then I would recommend that you write a letter to the court in support of your choice of guardian and why the other parent is not capable of caring for your child. You want to make sure that sort of you have an emergency contact person, and that person has access to your will and to your other documents, a list of your assets, instructions for your guardian, any information about your kids and how you want them raised. Also want to make sure you have life insurance in place, unless you have a lot of money and are able to, and that money would be able to cover all of the needs for your child until they're 25, until they're out of college, that it's really important to have a life insurance in place. And then we provide our clients with these emergency contact cards with sort of their emergency contact information on there, and our information as well, so because we would have that information in case something happened, that they could call our firm. Okay, and that's it. I'll open it up to questions if anyone has any questions. Feel free to put them in the chat or in the Q&A. I'm happy to answer them. Okay, well, I don't see any questions, so I will let you go. I hope that this was helpful. And if we can be of help in kind of protecting your family and making sure all of this is taken care of, you can reach out. There's our contact information on the screen. Oh, I do have a question. 25 is the age when children are independent. No, children are independent in terms of they don't need a legal guardian when they're 18. And then if in terms of when they have access to assets that are left to them, it depends on if the assets are left directly to the child, then it's either 18 or 21, depending on what the asset is. And then if you do leave the assets to a trust, which I would recommend, then you could put any age you want, 25 or 30, in terms of when they have full access to the money. Is the recording available? Yes, this has been recorded, and we will, it will be available, it will be emailed to all of the registrants. Great. Okay, well, I hope everyone has a wonderful day, and I hope this was helpful. And if there's anything we can be of help with, feel free to reach out.